tengere merobere ito yogosemia na gukomanya ya gukorekana kira rituko nabariki baitu be andrete chinga kichons asengincho yao eariganie asobo tengari botari no mubwekano. Eye ni Ensoko TV oboroso bumugusi umuruburi kubwatia na bukorigirirwa na kiro muntu.
Mwanchu Mogere Ensoko TV ni mambie ngia yeri tukerigaria 25 na kabiro mutinyino yokaru mwaka bwechile fuibere 25 na rimono kugena kwa rebna kwa bokire bya kwa genderero byase weekend yengi bana nderi tukoneria Jumatatu eiki yachakira senchira erendonge kegima na bogano gandira tukubwate Ensoko TV kuro chinsa 12 cheke mambi wekera bwana gachara gire chinsa inye chabona mambia ne chidakika nkego chia etire igoro enga kitoko swaso muroberiga bweterobini go chakira bwana weka chinsa isana ne mochabona mubaso aso kumorikirana ko rigeria ya gendere taya etire na boigo ayara kubwatia aseri tukerigana bwiganyone nase wiki yeiga engima tosangaso bwamo wetera senchira yo mutandao bwekerero Facebook rabaga sesemeria YouTube Ensoko TV namba mawasiliano nigere noti isano na ibere isano na isato isano na isato isano ne mumara gatano mwero beka isato tosangaso bwamo eritariane Ishmael Mogere. Asomo chakane mambia bono abarayibari me serikali ya Kenya kwanza bakorago no morogeri we serikali we bunge enene Moses Masika wetangula kurase county ya Vihiga ni gobaruro kubore guchia saba Kenya ko bari bo erimo erigo chikwenekia omorembe monogo bosibo bachore bonene bo mwaka bwechile fuibere 25 na kabere asenkwana ya kurase county ya Vihiga engakubekeranete asomo sangirikano bwogo changa nigo abarayabo kobomo batebina na nere byabarayigwetanga kurase siasa yugwatana na aba Kenya na boigo kubwatuka chinkwana echo chirarete omorembe imeyense erigo chikubwatirana guchekoreta monchirio imeyense na gwikerania amagendera soko sire serikali yerituko inse hyumrai wese Daktari William Samuel Ruto mase ya mugwikase county ya Vihiga na raliaya ari kura sensemeyo.
Tunataka tuwe na umoja. Hii western yetu hii yote, jamii zote za Kenya ziko hapa. Utapata jamii kutoka Central, kutoka Pwani, kutoka Ukambani, kutoka Turkana na sisi wenyewe. Tumekaa kwa amani kwa sababu sisi ni Wakenya. Na lazima kila wakati tusiwapatie nafasi watu ambao wanaeneza siasa ya chuki, siasa ya ukabila na siasa ya mapendeleo. Kwa sababu nyinyi mnakumbuka wakati wa mzee Moi mulikuwa hapa na mbunge mzee Khaniri aliyechukua nafasi ya Onam na Maisi. Tukasukuma huyu Gimoza akakuja, na Gimoza amekuwa ni mbunge wa kuunganisha watu. Nilisoma na yeye katika chuo kikuu na nimetembea na yeye kwa miaka mingi. Hana maneno mengi, hana matusi, hana chuki na mtu. Na hao ndio viongozi tunataka. Tusikubali wanasiasa wanaotembea na mambo ya ukabila. Juzi tumekuwa kule Murang'a kwa mazishi ya mbunge wetu. Tulikuwa na rais, tulikuwa na hao wabunge. Viongozi wengine wakasimama hapo. Nyandarua ni kama Kenya ndogo, hata jamii zetu ziko huko. Mtu anasimama wandu wa nyumba sijui nini. Kama kila mmoja wetu anataka kusungumuza mambo ya wandu wa nyumba, tutaharibu nchi yetu.
Na yale mambo nimesikia Mheshimiwa Cheruiyot akisema, mtaona watu wengi na kelele mingi na mipango ya migawanyiko ya ukabila na uchochezi wa kisiasa. Na tunapoelekea mwaka wa 2027 2027, uchaguzi unaokuja ni uchaguzi ya wale ambao wako na mpango na sera na ajenda ya Wakenya, na wale ambao kazi yao ni matusi, migawanyiko na kugawanya Wakenya na misingi ya ukabila. Na mmewaona hata hao, nasikia walikuwa hapa jana. Hiyo ni ile moto ya makaratasi ambayo inawaka siku moja alafu inazimika. Ndio unasikia ukiwauliza ajenda yao, hawana ajenda yoyote. Ukiwauliza mpango wa maendeleo wa nchi ama hata kukusanyika kwa kanisa kama hili kusaidia kanisa, hawawezi. Sababu ile kitu wanataka ni kuja kuwaletea maneno siasa, maneno ya uchochezi. Nimeona wengine huko Mombasa pia, ukiwasikiza hakuna ajenda yoyote. Yule mkabila kutoka huko kwetu, ukimwambia kuja hapa, atakuja kuuliza wapi nyumba yetu. Sasa mimi nilikuwa nauliza jana, tulikuwa Murang'a na rais na naibu wa rais. Wewe unajiita kiongozi, lakini wewe ndiye unajidai unasema mimi ndiye kiongozi wa jamii. Na tumekuambia sisi hatutaki kuwa viongozi wa jamii, tunataka kuwa viongozi wa Kenya, viongozi wa nchi moja ambayo inaunganisha Wakenya wote. Wewe kama unatafuta uongozi wa jamii, hiyo mambo yako ya ukabila, utajua hata watoto ambao kila siku unajaribu kuchochea hawana wakati na nafasi ya siasa za ukabila na migawanyiko ya Kenya kwa misingi ya ukabila. Nasikia wakiwachochea vijana, wanaambia Gen Z watoto wangu. Hao sio watoto wako, sababu hata wale ambao ni watoto wako sio rika ya wale watoto wa Gen Z. Sisi ndio tuko na watoto ambao niyo generation ya Gen Z. Na hawa watoto wetu hawajui ukabila. Wengi wao hata hawaongei lugha zao za mama. Wengi wao wanaangalia Kenya ya mbele, sio Kenya ambayo tulitoka nyuma, ambayo watu waligawanywa kwa misingi ya ukabila. Kwa hivyo
Wetangula amekaribia hapo State House. Nyinyi muanze karata ingine inaitwa Ososi Potea. Mtapenda hiyo? Aende ama asiende? Mnamwambia kutoka hapa Vihiga aende asiende? Ati anakutanisha watu ya matusi. Unaweza kuja kwa mkutano kutuzi wa mama na wazee kweli? Si unaleta maendeleo? Tusi tunatambua Wetangula, tunatambua Musalia Mudavadi, tunatambua Beatrice Atagala.
Kuna mtu hapa, kuna kiongozi aliongea kule Rwanda, akasema sisi watu wa Vihiga County viongozi wamenunuliwa ati na Ruto, wanafuata Ruto. We are not going to allow noise makers. Ruto anatupatia pesa kina mama vikundi tufanye maendeleo. Ruto anatupatia pesa sisi vijana wafanye maendeleo. Na mwingine wenye wanakimbia hapa kwa magari juu wakidanganya wakina mama ati one time sisi hatutakubali. Mkoa wa Magharibi na Vihiga ikiwemo, sisi tunaimba tu kuweza. Sisi tunaimba wimbo moja. Wazee wa Terix mmeweka tik, wamama wa Terix mmeweka tik, wamama watambua Jebkoyai mmeweka tik. Si mnasema Ruto 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 Ruto.
Unaona Kenya hii kwa sasa viongozi wengine wameweka taifa letu katika mambo ya aibu. Mpaka unasikia mhubiri anatuambia tuache maneno ya matusi, kwa sababu kuna watu wameshukisha heshima ya uongozi. Mtu anapanda juu ya gari na hakuna kitu ambaye wanaongea kuhusu. Kazi ni kumtusi na kumkejeli rais. Lakini mimi ninapenda kuwaambia nyinyi muendelee na matusi, rais aendelee na maendeleo, mtakutana na wananchi hapa mbele. Wananchi wa Vihiga, si mnajua hivyo? Hawa watu wa matusi hawa ambao jana wengine walikuwa hapa Vihiga, wengine walikuwa kule Mombasa, kuna kitu yoyote wa maana waliwaambia hapa? Kuna kitu waliwaambia? oh, sijui one term, sijui kasongo, sijui mambo gani, lakini mwisho ukiwauliza mko na mpango gani kuhusu wananchi wa Vihiga, hawana. Na unajua nilifurahi sana sababu mimi nimesikia mpaka rafiki yangu Osotsi jana akisema ati hawa akina Beatrice ati ni watu wamenunuliwa. Unajua, waja niwaambie, Vihiga hoye, Vihiga hoye. Unajua mtu mchawi anafikirianga kila mtu ni mrogi. Mtu broker anafikiria kila mtu ni broker kama yeye. Hiyo maneno naongelea iko kwa kichwa yao. Hao wanafikiria ati hao viongozi wanatembea na Rais William Ruto kwa sababu wamenunuliwa. Kile wanatuambia, wanauliza ati yao iko wapi. Sasa badala rais alete maendeleo Vihiga, ati anunue viongozi kama hawa walikuwa wanazunguka hapa jana. Tupige hesabu kama hiyo. Tufanye maendeleo ama tununue wale wakora? Si tuendelee na maendeleo? Sisi tunawajua vizuri sana wale. Na unajua speaker huyu hako hapa anaweza kukuambia vizuri. Ukitaka kujua matapeli na wakora wale wamejaa bunge, usitafute mbali, tafuta wale wakora walikuwa Vihiga hapa jana. Extortionist of the highest order. Wakora, watu ya wash ambaye tunawajua kwa bunge, hakuna siku wana support sera yoyote bila kuitisha pesa.
Kweli Gen Z? Nimeambiwa bado hamko kadi Gen Z. Mutahakikisha mko kadi, si ndio? Ndio siku yenye tutapiga kura tutaweka tutam. Na nataka kusema hivi, Mheshimiwa Wetangula ametembea na Dr. William Samoei Ruto, si ndio? Mtu number 1 kwa Kenya si ni Daktari William Samoei Ruto? Namba 2 si ni nani? Ni Kindiki. Namba 3 ni nani? Namba 3 ni nani Kenya? Ni Papa wa Roma. Sasa nataka kuambia nyinyi, hii safari tunaenda, safari ya William Samoei Ruto ikiisha 2032 tunakuja pande hii ya Western. Munafurahi na hiyo maneno? Tutatembea kwa hiyo safari pamoja, kwa sababu sisi ni jirani mwema na tutaendelea kutembea kama jirani mwema. Na leo nimekuja hapa kuchangia kanisa letu la Terik, kanisa yenu ya huku, kwa sababu mmeshikana wote. Mimi pia nimekuja na mchango yangu ya shilingi 1,100. Nikifika pale
kaunti ya Vihiga tukira nase kaunti ya Nairobi omuraiwe kiama kia DCP Rigathi Gachagua nigare no kwigena buna nachikonyoro bwene no bubui wetera ase ekigambiro gose wetera ase na chira chikuruga kurwa ase ekigambiro chinga kiritiko lia rero ekino gyokurusi kwa ya bisi gia chakire bono gia chakire bene emambia ya bono ase ekigambiro kia milimani ase omuchoyo iga o Nairobi. Gachagua ase ekina ekeiga nigo korengana neramo ngaki asogosanga kwa ya mona Ibande buna Kalonzo Musyoka wekiranire ase ekigambiro kia milimani mambia ya boro. Kalonzo sensemu yae nigaerere buna okugena nkorona Rigathi Gachagua na chikonyora obwi engakingo kwira ya mase mwekira ase ekigambiro kia milimani abwase bono wekira boni gaba igereria ba Rigathi Gachagua bagenderete kurwa enkwana yabo ase kurwa sensemeria yokumwegerera Rigathi Gachagua ya mase mweka ase ekigambiro kia milimani.
Day before this law. My Lords, paragraph 1 to 19. My colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April, 2026. Thank you. My Lords, Your Leaderships, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this Honorable Court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this Honorable Court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this Honorable Court to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 8, 9, and 10 and 11, and they appear from page 8 of our written submission. Paragraph 8, the Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution, the standing order, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced as scheduled on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination. In this Honorable Court, you'll be taken through all that from a learned friends here. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President of the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 counts. And you find all that in RG 11, volume 9, pages 1689 to 1725, response by Brigadier Gasham. And also RG 12, volume 9, pages 1752 to 1758, the communication from the chair. My Lord, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the prime minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution that members of the National Assembly can vote and christen their resolution that they are breaches of the Constitution, and you'll be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. In other words, what I am highlighting here is what the court says in the song called Moving Gideon Kioko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I said, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the deputy president to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different countries. Now, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations, whether that was unconstitutional. My Lords, Your Leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, the notice of motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, Your Leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing the Wabora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wabora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution or other written law. They didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wabora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterated will apply to the impeachment of the president himself. It's very weighty issues that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles, of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code 5 years before the Deputy President's election to office. Ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law, warranting his removal from office. By impeaching the Deputy President on the basis of a section that had been nullified by this court, what Sigin knew was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. My Lord, you find that authority, paragraph 62, allied case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Leadership, the Senate voted on that impeachment charge on the basis of a repealed section. You find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security. And my Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner, criticizing the NIS director. My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, sub-article 5, is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is 206 of the laws of Kenya. You will find in Part 3, civilian authorities, the heading, effective civilian authority. They then say that the cabinet secretary will be the civilian authority oversight. The cabinet secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that would take up these issues. But criticism, despite the freedom of thought and expression in our Constitution, the first petitioner was still convicted for criticizing the NIS director. So, my Lord, Your Leadership, what you are submitting here is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced Ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of Ground 2 and 3, it still voted to impeach him based on Ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Rigathi Gachagua had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken first to the National Cohesion for prosecution before invoking the last resort remedy of impeachment? Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal. on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in Ground 8 that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering, the Deputy President explained that no valuation had been done, so where the National Assembly, Honorable Mwengi Mutuse, got 5 billion is anybody's guess. If you want to charge somebody, you present them that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Derito Gachagua. May his soul rest in eternal peace. Some, like the Olive Garden Hotel, Vipingo Beach Resort, Queensgate Serviced Apartment, he did not even own. And yet, this was what he was impeached on. But we are falsely attributed to him. He produced ownership document showing otherwise, and you will find that, my lord, in RG2, Volume 2, pages 211 to 214. Lords, although the mover of the motion listed that the 2 companies associating them with the petitioner, first petitioner, alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety, and you will find that in RG2, Volume 2, pages 214 to 218. The Speaker of the National Assembly, again, a good professional colleague who I respect, did not direct the members to the threshold test, the appropriate standard. Hence, the resolution was passed in proceedings conducted as a vote of no confidence, rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you'll find that as message of the Senate, number 025 of 2024, approval of special motion, RG3, Volume 6, 745 to 745. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds that, 1, the impeachment motion was replete with the general unsupported allegations, hearsay, and outright lies, and lacked particularization and specificity required by Article 145(1) of the Constitution of Kenya and Standing Order 64(1)A of the standing orders of the National Assembly. 2, members of Parliament debated and voted on the motions on grounds other than those set out in the motion. The impeachment was converted into a vicarious assault on family rather than investigation of constitutional violations by a public servant. Members of Parliament, let me skip that and go through the next one. The entire impeachment process was designed to avoid and be ring-fenced from scrutiny and accountability. Pushed through with uncharacteristic speed with the intention of ramming the process through before it could be audited for constitutional compliance. The National Assembly prosecuted proceedings on the basis that the petitioner offended the president rather than the Constitution. What the 2010 Constitution provides is violation of the Constitution. In other words, the president must take time and choose his deputy. And Lord, I don't need to take time to go through what the country was put through between His Excellency Daniel Toroitich Arap Moi and his Vice President George Saitoti dangling the Vice Presidency, requiring the President to choose his or her deputy before the election so that the people could themselves vote is a very important aspect of our Constitution. The National Assembly trivialized the gross misconduct standard set out by the Constitution and other statutes for holding public servants to account. And, my Lord, I will not repeat the Wambora case, but I would state the impeachment motion was replete with generalized statements, unsupported allegations, hearsay, outright lies, lack of particularization and specificity as required by Article 145. My Lord, the exposition on all that is set out in paragraph 36 of our written submissions, and I will not take the time of this court going through them. I invite the court to read through it when we retire. Despite these glaring and fatal flaws apparent on the face of the motion, even on a cursory review, soon after the impeachment motion was tabled in the National Assembly, the first respondent issued a communication from the chair, number 46 of 2024, in which at paragraph 16, 18, and 20, he stated that he was satisfied that all the grounds in the impeachment motion met the requirements of the threshold under the Wambora case. The first respondent legally incorrect decision to allow the motion to proceed for debate, despite its clear failure to meet the specificity and accuracy requirements of the standing orders, seems to have been motivated by Parliament's biased and reckless haste to pass the motion as quickly as possible in order to shield the process and its obvious serious rules from judicial review. It is our submission that that was the real reason for the rush. My Lords, Article 50, Sub-Article 2B of the Constitution states that every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence. The motion thus violated Article 50, Subarticle 2B, and Article 50, Subarticle 2J of the Constitution by setting out vague allegations, criminal conduct, including the Deputy President had violated and repealed sections of the penal, the leadership and integrity without ever charging. Overall, the impeachment motion of the first respondent's communication from the chair was thus incapable of invoking the National Assembly's mandate under Article 150 as read with Article 145. My Lord, you will see all that in RG 1, Volume 1, pages 2 to 41, and RG 8, Volume 7, page 969 to 976. So, my Lord, that is all I wish to say about A. Let me very quickly move to C. My Lord, issue C is there a problem with your gadget? Say hold on. I'm listening to the gadget. My Lord, issue C is whether the Senate.
Do I need to remind you about time?
Only another 10-15 minutes.
You have here 5 minutes.
Yes. Moving as quickly as I can. See, my Lord, which you find at page 40 of our submission, is whether the Senate misled by its misinterpretation of Article 145, rushed the process and denied the Deputy President here. The Senate, my Lord, recognizes the right to a fair hearing in considering a petition for removal of a person from office, because they say so in their standing order number 81, the right to appear before the committee, the relevant committee. That is in standing order number 81. Whenever the Constitution or any other written law require the Senate to consider a petition or a proposal for the removal of a person from office, the person shall, and the word used in standing order number 81 is that the person shall be entitled to appear before the relevant committee of the Senate. The petitioner here was denied that opportunity to appear before the committee. And the importance of the committee, my Lord, is that the committee
aine gatiaria gendrete kurwase kigambiro kia milimani asumucho yo Nairobi agwase ekine gyokuruswa bisi kwoyo kabere omukonyi bo muraibwense ya Kenya Rigathi Gachagua ngo kwenyorina Rigathi Gachagua ni garuse tu abisi kitariki cyarenge 15 na ibiro mutenyi no yo 10 omwaka gwe 2024 wetera ase kina kiabegetwe ase bungeria nene na boigo asama mocho alenge au ayo alenge amamocho 11 abwo ase wetera ase amamocha yo naro asite kwerero kuruswa kwaye abisi kitariki cyarenge 15 na ibiro mutenyi 10 omwaka gwe 2024 nekire kiaye nigo kirachikoire gwika amatuka atatu rero neri tukori tangani na boigo ritukori yankyo na boigo gwika tukori Jumatano chingaki enachi erache kurwegwa igoro yekine kigagyo kuruswa kwaye abisi Rigathi Gachagua ibo igoro muraibwe kiama kya DCP tugosuka mutwe ase ensemo yende na nyuma na ntochikuranira yo ase obwagare eryo gendere kwemenya magana ya yagendere tukurase kambirikeri kya milimani ensemo yende togoswase omoicho Kisumu ensemo ya kabiri kya kia ODM yekoragwa na Edwin Sifuna bwa igoro mosenete we county ya Nairobi amanyekere buna Linda Mwananchi nigo aseri tukore igoro bakorete tari abwe kase county ya Kisumu abwase konyari korwari tangani ubwo bwarenge korende musangirikani uyu ugakorekana se county ya Kisumu asenkwana yabo yabarai nigo bagendera ko moche serikali ya Kenya kwanza asogotekirani obokoreri obwikirani gucyase omo Kenya guchakirense moye chisemi obo chenu oborende naboigo ase amangana au ayo arengeto Mwananchi mwambia yabore masemo ikasense yiturali nariaya agendere tukurase ensemo eyo yensemo ya Linda Mwananchi county ne ya Kisumu.
Niseme nisiseme, baba aliniambia hakuna siku sisi kama watu ambao tunaamini kwa haki, sisi ambao tunalinda wananchi, sisi watu ambao tunajua kwamba maslahi ya mwananchi lazima iwekwe mbele, hakuna siku tutatembea na wakora kama Mheshimiwa William Ruto. Haiwezekani.
When the scholar speaks, is speaking to help of the party.
Yeah. Na baba aliwauliza, kwa nini mnaogopa bwana? Kuna watu walikuwa kwa darasa ya Raila Odinga, ngoja tu kijana. Kuna watu walikuwa wanalala kwa darasa ya Mheshimiwa Raila Amolo Odinga. Wewe kama haujaiva, toa jam, wachia wale watu ambao tulikuwa tunachukua notes tusonge mbele, si ndio? Baba aliwauliza, wewe unasema Ruto 2 term. Nani alikuambia ODM haiwezi kutoa rais mwaka 2027? Who told you? 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 Asante sana DJ. Muliniona mimi Sifuna pale KICC tukitengeneza mkataba na chama cha UDA. Hiyo mkataba nataka niwaambie leo vile baba aliwaambia, mimi ndio niliandika hiyo mkataba. Naijua nje na ndani. Mnanielewa nyinyi watu? Tuliandika pale kwenye huo mkataba kwa sababu watu wa Kisumu ndio wamepigwa zaidi na polisi. Sisi tulikuwa tunaona polisi wanaingia kwa nyumba kule Nyalenda, wanatoa mtu bila hatia yoyote, wanampiga wanamuua. Polisi wa Kenya ndio waliua mtoto msichana anaitwa Baby Pendo. Waliua, hawakuua. Tukasema ndani ya mkataba na MOU ya chama ya UDA lazima wale ambao walifanya hiyo vitendo waende jela, na familia ambazo ziliathirika zilipwe pesa. Pesa mumepata? Pesa mumepata? Tuliambia William Ruto baada ya kuandika huo mkataba, hatutaki vijana kubebwa ati kwa sababu umeandika kitu kwa Facebook. Wewe fikiria, polisi walitoka Nairobi wakaenda mpaka Homa Bay, wakachukua Albert Ojwang, wakaenda wakamnyongea ndani ya cell kule Nairobi. Na hiyo siku, niseme nisiseme, hiyo siku waliua Albert Ojwang, ndio siku Sifuna alitangaza kwamba huo mkataba hauna maana tena. Na hapo ndio shida zangu zilianzia hapo. Wakaenda kunistaki kwa Raila akawafukuza. Wakakaa wakangoja baba yangu akufe. Siku ile baba alikufa ndio nilijua chuma changu kimotoni. Wakora wananiambia, Sifuna wewe ndio ulikuwa rafiki ya baba, enda umlete kutoka India. Mimi nimeingia ndege bila kujua, jamaa wananichorea. Sisi tunaenda kuleta baba, jamaa wamekaa hapa wanaweka hila kuingiza Mheshimiwa Oburu kwa ofisi ya party leader. Mimi nikirudi na baba nakuta tayari wamefanya hiyo mabadiliko. Chama cha ODM kiko na katiba inasema tuitishe uchaguzi, Mheshimiwa James Orengo ajitangaze aseme anasimama kiti ya party leader. Tukutane na huyo Oburu. Mnaona nani atashinda hapo? Nani atashinda? Orengo ama Oburu? Party leader Maru kuja hapa. Mheshimiwa Orengo.
Siku ya leo tuko hapa, nikikuangalia wewe kijana, najua siku moja utatoka Manyata, najua siku moja utatoka Nyalenda, najua siku moja utatoka Ubunga, najua siku moja utatoka Kondele, najua siku moja utatoka Kawosh, najua siku moja utatoka hapa. Na Mungu atakupeleka wapi? Shida zetu zote ambazo tuko nazo maishani ni serikali ndio inaleta. Tunapanga laini, tunapiga kura. Tukishamaliza kura, development haikuji hapa. Industry kubwa hapa Kisumu ni ya bodaboda. Kijana anamaliza shule, anafanya degree, anafanya skills, anafanya mpaka driving, kijana anarudi kukuwa dereva wa bodaboda. Ni ungwana si ungwana? Alafu tunaambiwa tuko broad based. Ni upuzi si upuzi? Ni ushenzi si ushenzi? Wewe kama kijana unaamka asubuhi, unatoka unaenda mjengo, unatoka unaenda jua kali, unatoka unaenda kuendesha bodaboda, alafu unaambiwa ya kwamba ukirudi jioni hakuna pesa, hakuna hela. Bibi anakuangalia, mtoto anakuangalia, hakuna school fee. Bibi anakuuliza maswali, hakuna chakula. Mnaanza kuulizana kwa nyumba na mnaangaliana, lakini hakuna majibu. Tunasema enough is enough is enough is. Tuko na baba yetu hapa. Baba anatoka hapa, amefanya kazi maisha yake yote, kazi ya jua kali, anaenda kwa matibabu hospitalini. Kufika kule, gharama ya afya iko juu. Afya si bora tena, ni bora afya. Alafu huyo baba hana shilingi 500 ya x-ray peke yake. Alafu unaambiwa hapa, ukiniangalia ya kwamba uko katika broad based. Broad based ni upuzi si upuzi? Ya ujinga si ujinga? Viongozi wote wanakuja kuongea hapa, kuwaongelesha, wanaambia broad based ni nzuri, na hao ndio wanapewa pesa. Hiyo pesa inawafikia? Hiyo pesa inawafikia? Siku ya leo wanahaya goons, wanataka goon akuja kuue, wanampatia 1,000, na huyo goon tunamwambia hatuwezi mlaumu kwa sababu hana kazi, lakini tunawaonya magoons, huwezi uwa ndugu yako, huwezi uwa dada yako, huwezi leta shida kwa sababu ya mambo ya goon peke yake.
Winjima, the Luo nation has defended Kenya. The Luo nation has fought for Kenya. The Luo nation has died for Kenya. You look at Jaramogi, you look at Raila, you look at Tomboya, you look at Ensoko. We don't want the Luo nation to lose the dream. Raila told us, when I die, don't sell my land. I am asking Oburu, after Raila dies 2 days, why are you selling Raila's land? Where are the children going to go? Are we together? Harambee! 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 Ruto must!
Hapa nilikuja nikafikiria nilipoteza baba, lakini wakati nimekuja Kisumu leo ni kama baba Raila Omolo wako hapa. Wale wanaamini baba wako hapa wapige mkono tuone. Baba wako hapa yuko. Baba yuko hapa yuko. Baada ya baba. Hey, Caleb Amisi, I endorse Babu Owino. Babu Owino. Huyo kijana mshikilie. Mimi nimekuwa na campus University of Nairobi. Kijana ako na akili mingi, na ukitaka ujue kiongozi, ule mtu mwenye ameshikwa akapelekwa jela kabla ya baba peke yake alipelekwa jela. Baada ya baba ule amepelekwa jela kupigania wananchi ni babu. Kama uwezi kuwa kiongozi ya Wajaluo kama hujaenda jela. Baba alienda jela, babu ameenda. Huyo mnamkubali? Mimi leo hii nimeona the spirit, the dream, the vision, the mission of Raila Amolo Odinga in this team. Sasa babu akipewa awekelewe mafuta na apewe advice na Governor Orengo. Sikizuma mesonga mbele, Sijaluo imeenda mbele. Basi mimi nimekuja kuambia hivi, mimi watu wa Kisumu nimetoka Ukambani kuja kuwaambia tunawaangalia na macho yote. The democracy of this republic has been defended by the people from Luo Nyanza. Na leo tumeona na macho yetu kabisa. Wangapi wanasema hali ya maisha iko juu? Wangapi wanasema lazima tuwe na structured system of education? Wangapi wanasema lazima tupigane na corruption? Na mnajua itatoka kwa hii team. Kwa hivyo tunasema Ruto must. Thank you very much. Mwaka wa 2022
Nataka msikie vizuri. In the year 2022, nani aliiba kura ya Raila? Nani aliiba kura ya Raila? Ruto aenda nyumbani ama siende? Ya nne, Ruto aliweka mkataba ya 10 point agenda. Hajatimiza hata moja. Ruto anaenda nyumbani ama aenda? Aende nyumbani ama aende? Na kuna wenzetu wameuza chama. Kuna wenzetu wameuza chama. Umejua wale wameuza chama? Umeuza wale wameuza chama. Waende nyumbani ama siende nyumbani? Oburu aende nyumbani ama siende? Gladys Wanga aende nyumbani ama siende? Juneta aende nyumbani ama siende?
Miamana soko chora Ensoko TV buroso bwo mugusia sabona ni goto korasi umiri chiduka keigo na nyuma yo gusumiri chiduka ningira nena yanda mange to uskare ne TV yao.
Eye Ensoko TV uboroso bw'umugusi obutindi n'obusumbasi amate ninkikere tokore
asama getango ko munyagitabo sile ko Betami Rehabilitation Center. Betami Rehabilitation Center toka asegusi ensema ya Gesonso na Nairobi ga ogoche ensema ya Ungatarunga Xerian Road. Ime Betami nigo togo konya abantu bari amaruna amaryogo yogotindi asariri obongo bwabo. Togo konya abantu buna umwana funzi orenge kwende university ongere gotumia amaruna amaryogo yogotindi amosariri bono yakireke wango guikarwari. Panya oroyo onde orenge kwende kanisa otigire onge yakonywa amaryogo yogotindi na amaru abasari. Erio twabaretaga Betami twabarwari erinde obogima bwabo bwirane gochaso obogima bwe
asamange twakirisimia se namba 0706840844 Betami Rehabilitation Center lichi buri gukora chingatare icyobutindo.
Omurayi omukuru bwense ya Burkina Faso Thomas Sankara niga tebete nige kuira ekerengo gete kyobo balimo kibirengeralio eliokolenta amontelio ya magenderero asama tukabusio na kyoge kogera omuseneta Gloria Oruoba erure koba ebalimo yaino aso musimamo y'omutindi akonye kurwanerera omugusi inyora omusike Oruoba nigalenge omuseneta omuchorwa weki magia serikali gya UDA kurende agesokya kubwatisia omurwandereria wekerugo kyobura ibwense kurwa orogonko rwagusi omuske Dr. Fred Matiang'i abange bakamuruke balimo igoika kaurwe kerugo kyaye kyobo seneta asogotenena no mugusiyo mwabo no nyabono atabwatie mirimo obeire okurwanirira abasubati wekinia kiuchumi koenana ebitamba byobochenu naboigo kurwania chisegi chiegenka bono nigo abolirio mugusi komochora buna omu women representative bwe county ya Kisii asobochori bwo mwakugocha elio aire obubalimo bwaye alia sebunge agenderere kurwanirira omugusi emeremeye nigetage tomusubati omulemu Oruoba narokwe balimo takumeti kugicha obubalimo bo bokonye kurwanirira omugusi mbuya gutwara omusubati omulemu gose balimo kubwa gutwara omusubati omwoba okoni gesaku oyo nere Gloria Oruoba ebalimo yagusi.
omwancho Mogere Ensoko TV
igetaseni Ensoko TV nibwatira sengencho yao
kokoretera amang'ana amaya
ayatabwati gwanchero konsi kolime yagusina isiko yagusi
to kubekera tene ni anyare koba kawateka
atabwati gwanchire bonda bwensi
korwa se bunge ya kitutu chache South Meye County ya Kisii elietari anen Caroline Mausa
korwe county ya Nyamira elietari Nyariki Steven Embonde
korwa se county ya Kisii elietari ane Wycliffe Orenge
mera na inche Dominic Onderi Nyabuto ekenanya gukoreta amang'ana amaya koruritu kuri Jumatatu paka ritu kuri Jumapili
tini gongoro perpetual machini na nyora Etorobini Ensoko TV oboroso bomogusi
Nyamira na rena shauri zangwe ngararombo ijano umozu batera mabwari
Mogere Ensoko TV oyo no moroberio gwokongoria mareko na inje mwana mboka Edwin Nyang'au turabe tukumira na kira ritu kurie iki guchakira chinsa 11 chamogoroba wikenseyemo ya butuko kugwakorire imirimo yawo yerituko kwabukire orosete uikaransitero ya ubwo yandagita sekerugo orambulete merundo kunyagusibero ngori naria se screen ni chingero chikoletwa na mwanambuka Edwin Nyang'au ano to konyora chingero chionsi echiegita na chobenga kwa nubukano echiembegetere ndo gesongengo to amereria
bakaliya omoto yakabwatwa bakaliya omoto yakabwatwa amatukemero ngena gaika kabwatwa
mirna nabali bechinguru erikwe manyabo na wataka kurchitana nyechense Frida Kerubo Innocent Onyango Clinton Ondigi Diana Ndemo Ishmael Mogere Linet Nyambane Daniel Omwaga eke nakige kos kiamesa yamangana maya amarire nigagendrete gutose mwana boira bukia tali yesu sera eke gonko esukari lisabeso okurasa kwa manyinga yan blood pressure ninki turakole wetanga kuri wasare nyorali chibu asomrobilyo bubugima nobo cheno asora bego kumani wanabanyagitari bamarwire ao nabo yabamanyi bande bayatunge tyobo cheno kumurikira marwire nobo wenia nyoro mrobilyo bubugima nobo cheno na Caroline Mausa kirali tukule Jumatatu chinsa ibiri chabutuko ime Ensoko TV oboroso umogusi eye Ensoko TV oboroso umogusi
Mogere ya Ensoko TV eritwendera kwemenya mangase emambia yabono omwana mumurabwe emyaka 14 nigasire ubugima bwaye asinchira yobo tutukwanu magega yomusani obwe emyaka 15 gukagirwa kumurasa risasi ekenyero gya Kinamba Sosiane County ne ya Laikipia nyagusira omoro kiwe grade gya Kianda nigo egotebekana aya nigakorekanete chinga kibachete gutwara ase konya baitire Enyang'au no musani oye uyore omwana bwomo songo abamenyi benseme iyo abo bayichire no gwichana konene bakoragwa no MCA Sami Lokopien nigo baganirie amate yanyagusira konyora obwene bwabo ase enchira ere yobwasioko.
Huyo mtoto ameuliwa na mtoto ya mzungu anasoma na kijana yangu. Kwa hivyo ni jambo ya uchungu zaidi kuona mtoto ya mzungu hana haki ya kuua mtoto ya Mwafrika. Kwa sababu leo huyo mtoto ataua mtoto mwingine kwa sababu tunazingirwa na mashamba ya wazungu, bado kitendo kama hiyo itatendeka. Kama serikali iwezi chukua hatua, ishukue at least huyo mtoto wa mzungu, tuone justice inatendeka. Huyo mtoto akiweza kushikwa ama mzazi yake, tutaona kuna haki inatendeka hapo. Kwa hivyo yale mimi nasema tu, tumewashia serikali na tumejaribu, tutaongea na walimu wote, hakuna shule itafunguliwa mpaka tuone justice inafanyika kupitia.
Ninajua serikali hii ambayo tulichagua ya William Ruto imeweka kitengo ya minority pale State House ambayo inaongozwa na Director Lowoi. Kwa hivyo tunamuamurisha kama jamii akuje aliye na hii jamii, kwa sababu kitu ambayo tunataka ni haki itendeke. We demand for justice. Na hii ambayo imetendeka hapa, mtoto wa kizungu anakuja kuua Mwafrika na kumenyamazwa, tunasema this is a test for justice. Na kama serikali haitachukua mkono, jamii hii na wazazi hawa waweze kupata haki yao, tunaona ya kwamba serikali ni ya mabwenyenye, si tena ya wanyonge kama vile tuliambiwa wakati tulifanya uchaguzi. Kwa hivyo ninaomba sana tuweze kupata haki, na mimi ninaomba president wa hii nchi atume Director Lowoi mpaka kwa hii kijiji akuja ajione kwa macho, kwa sababu hapa tumepata kifo na pande huo mwingine hatuna makaburi. Pia makaburi imefungwa na bado ni wazungu tu. Tunashindwa hii mwili tutaipeleka wapi, na hatuoni wale ambao wanatutetea, yet tulichagua viongozi. Kwa hivyo tuko hapa siku ya leo kudemand for justice. Tunataka justice na hakuna kitu kingine.
Niko na uchungu kubwa sana kwa sababu leo tumesunga tukipeana basari, ili hali wale watoto tunapatia basari tushampoteza mmoja. Ni uchungu kubwa kwamba mtoto kama huyo, mtoto mdogo ambaye ni miaka 13 anauawa na mtoto mwenzake ambaye baba yake amemruhusu kushika bunduki. Mimi kama mzazi, hata mkuki yenyewe siwezi ruhusu mtoto wangu mdogo kushika mkuki kama hiyo, kwa sababu anaweza dunga wenzake, anaweza dunga madada zake ama ndugu zake. Lakini ni mshangao kubwa ya kwamba mtoto anapewa bunduki na mzazi wake aende akawinde msituni. Na mimi kama mtu mzima, hata kwenda kuwinda pale lazima idara ya KWS ikuwe hapo, na lazima wajue ni nini imetendeka. Mimi nashindwa hapa nyuma ni nini kiko ambayo ni nini inafanyika, atuambie. Mimi naomba serikali ya William Ruto ambayo tukifanya siasa walisema bottom up. Wamesema hii serikali ni ya mama mboga na mkulima. Mimi nimeshtuka kwa siku ya leo ya kwamba mama mboga na mkulima watu wanauana mwenyewe. Nasikia uchungu ya kwamba pia nikiwa kijiji cha Sosian ambayo tuko na serikali gatusi ya County Government of Laikipia, wakazi wa hapa wamekatazwa haki yao, kwa sababu ukiwa na kijiji kama hii kuna maafa. Na kama hii ya leo ambaye mtoto amefariki leo, ameuawa bila kuwa na ugonjwa yote, amepigwa risasi na mwenzake ambaye ni mwenzake wa Kisungu ambaye ni rafiki yake, amekuja kumchukua kwake. Tulifikiria kumchukua kwake ni kumchukua kwenda kucheza na yeye na kuishi maisha mzuri na yeye. Hatukujua ya kwamba atachukuliwa akiwa hai arudishwe kwa maiti.
Mtoto ananiita chocho. Tuko na uchungu mingi, yale hatujui tutafika wapi na tutaelekea wapi. Sisi tuko na uchungu mingi. Mama yetu mzazi tena aligongwa na mbogo na hakuna chochote ilifanyika kama wa serikali ilitusaidia. Mzazi bado tena naumia. Ndio hii tena mtoto wetu bado hiyo siku tu, wakati hiyo tumelemewa na mashida mengi. Kwa hivyo kama serikali inaweza kutusaidia kwa kila njia, itusaidie. Yeye tu.
Niliamka asubuhi nikasikia makelele ya huyu mama ya mtoto mwenda zake aliyehaga kupitia risasi ya bunduki, na nikachukua hatua, nikaenda mpaka huko, nikajionea kweli ni kweli kwamba mtoto amepigwa risasi. Nilienda huko saa 3 ya asubuhi, tukakaa mpaka saa 5 hivi ndio maaskari ya DCI walikuja. Kulingana na ushahidi iliyotolewa na wenzake wale walikuwa pale, ni kwamba huyu mtoto wa mzungu ambaye alipiga mtoto wa Mwafrika kama shabaha ana mazoea ya kuinda wanyama hyenas usiku. Kazi yake ni kuinda wanyama usiku, na anatumia watoto wa Afrika kumulikia yeye hawa wanyama na tochi usiku. Siku hiyo kweli waliua hyena moja, mimi nimeona, na wakatoka kwa huyo mnyama waliua, wakakuja hapo kwa boma mbuzi, wakaamusha hao wachungaji wa usiku. Walipokuwa wanawata moto hapo, wakasikia sauti ya hyena mmoja akisema hapo kwa msitu. Huyu mzungu muuaji ama mtoto wa mzungu muuaji aliambia huyu muadhiriwa, amka twende, ndio huyo mnyama tunataka. Tangulia. Huyu kijana kutangulia hatua 2-3, akamshoot kwa nyuma. Kabla hawajafika mbali, akaua huyu. Kulingana na ushahidi uliotolewa huko, walisikia huyo hao wachunga usiku walisikia risasi 3. Na kweli tuliona maganda hayo risasi. Ndiposa huyu mzungu kufikia hapo, huyu mchungaji wa hapo alikimbia, akashika huyu kijana mzungu, akanyang'anya bunduki, akampemperesa, akarudisha kwa gari. Ndio wakaweka hiyo maiti kwa gari, wakapeleka mpaka kwa askari yao wa KPR. Huko imejaa askari ya KPR wengi sana, sijui hata bunduki serikali wanapeana bunduki mingi namna hiyo kwa shamba ya mtu. Ninashindwa kujua kwa nini. Sijui kuna vita gani kiwango hiyo. Tunaomba serikali ya Kenya waangalie vizuri sana wanapeana bunduki wapi, kwa njia gani. Inafaa serikali ya Kenya ichunguze haya mashamba yote, kwa nini wanapewa bunduki kiwango hii. Ni ya kupiga watu weusi shabaha, ni ya kuua wanyama. Wapi KWS? Wanyama wanawawa huko na KWS wanasema ati tunalinda wanyama. Si wakuje waingie kwa haya mashamba waone vile wanyama wanauliwa. Ni mbaya sana.
Nayo gose kutigana nayo kurase county ya Laikipia rikoligereria haya bwate kaine n'abarimu ime yense niko abarimu niko bagosereri gucia gokora kurobekana konye serikali teri guchikoene kiabuna nkonyora bari obokoreri obwekiranu buna abarimu ase obokoreri bwabo ime yense ase okurwa amagirgo chiase aborkiwa ase enkwana yabo winseye kiombe kiabo gya Kupet niko barere buna ase ensementangani yobo chenu tibara baba konyora obokoreri obwekiranu gwetera somurubiro bwabo chenu omanye nebunasha abo asensemo yende baganire serikali kobarika abarimu baisaine nabego ase ensemo yende kuligiria makongu ao ayo korengana no kwigwana babire bakubeka ase myaka ya magiga serikali itarabake gwikirania buna ebwenderete ya mase ya motorali na raliaya ari kuru asensemo yabarimu nekerero kiabo nkerekieke guchiase serikali yenene.
I want to address NEC. Many teachers who are contracted in various roles in last year's examinations have not yet been paid. Their payments, they have not received their payments despite carrying out demanding duties with dedication and professionalism. The delayed payments have lowered the morale of the teachers, weakened the trust in the institutions, and undermined the value of teachers' contribution to the examination process. Kupet Narok branch, we are calling on the Kenya National Examination Council to urgently settle all the pending dues without further delay. If this matter is not addressed as soon as possible, members may consider lawful industrial action and other
appropriate measures to seek justice. Kubet power.
Power.
Kubet power.
Power.
We are saying if NEC does not pay teachers promptly, we are going to move to the street as soon as possible.
SHA, teachers continue to experience serious challenges in accessing medical services under SHA. Among the serious concerns include, but not limited to, number one, hospital rejection, detention, and denial to treatment. Some hospitals decline SHA or demand cash, which should be paid upfront before the treatment starts. Teachers are detained in hospital over unpaid bills or forced to leave title deeds and other property as surety. Many accredited hospitals have withdrawn or are not on board, limiting access to care for the teachers. Number two, system failures and digital inefficiencies. Frequent SHA system downtime disrupts treatment and delays service delivery. OTB delays, fingerprint validation failures, and portal glitches deny teachers access to treatment. Number C, delays in pre-authorization claims and emergency care, long delays in approval for treatment, especially emergencies, specialized care, delayed processing of claims, including last expense claim. We have such cases in Narok, and there are many which have not been dealt with. There is also lack of effective ambulance service and emergency response. Number D, inadequate coverage and reduced benefits. SHA benefits are not comprehensive compared to the previous scheme that we had, that is Minet. Critical services are not covered, including IVF, optical, dental, oncology, care, physiotherapy, specialized tests, and evacuation abroad. Teachers are forced to pay cash for many essential services that we have. There is also number E, low cap, co-payment and financial burden. Outpatient limits has been capped at between 1,200 shillings to 2,500. This is too low, ni kidogo sana. Walimu wanateseka, wakifika kwa hospitali wanaelezwa walipe. Hiyo tunakataa. Number E, there is also high consultation fee that consumes a lot of money from this one, which is between 1,200 to 2,500. Teachers face heavy out-of-pocket expenses for drugs, scans, and diagnosis. Number F, which is the last one, is administrative confusion and dependence challenges. Missing dependence on SHA. A lot of teachers are experiencing that they don't find their children in the SHA portal. Challenges registering children above 18 years old, between maybe 18 and 24. They are still confused, and the SHA is not having all the details of all the teachers. There is a lot of confusion in the job group. Benefits eligibility and lack of clear reporting channel. Whenever we have any issue, we don't know who to report to. We want to urge SHA to ensure that they rectify. And then the last one is about the maternity. Maternity benefits, they have given the D5 teachers who are already approaching above the age of 45 a lot of money. That is 358,000 for maternity. And these are the teachers who may not be of childbearing age. The one below, this one of C3 to C5 there, who are childbearing, have been given 120,000. They are not benefiting them because this is the age that are childbearing. Wala ambao wamewacha kuzaa wamepewa pesa mingi. Wala ambao wanazaa wamepewa pesa kidogo.
I'm going to talk about the autonomy of the junior schools. This is an issue that the government is playing a hide and seek game, and we want to be straight. Students who left the junior secondary school to join senior secondary school were wasted, all time wasted. Those who went to secondary, we have been forced to now train them again afresh. So we want the JSS to be an independent, a standalone institution. This is because we see that the leadership structures are not working. You cannot place degree students under P1 leaders. It is not working. The war between the JSS and the HOIs has made the students to suffer. The learners, they don't know anything when they join grade 10. That is one of the reasons why we need the autonomy so that the students can benefit. Secondly, we have issues of co-curricular activities. Currently, the JSS activities, co-curricular activities are merged with the primary school activities. The number is big and it is not possible even to identify talent correctly of the JSS students. So we would like games, music, KSF, drama to be run independently so that the JSS teachers can also have their roles as referees and also coach their teams up to national levels. There is also an issue of their progression, career progression guidelines for the JSS is not clear. We don't know those who have already taught for 3 years whether they're supposed to move to job group C3, and it has not happened. And once they move there, they will already be above their HOIs. So where do we place them after they are senior now than the head of institutions? So we want a clear guideline for career for the JSS. The other thing is we have congested the primary schools with the JSS population. The government started by building 2 classrooms in secondary schools, in senior secondary schools. Those classes now are being wasted. Primary schools do not have laboratories. These students are just doing theory. Even when they were given an exam for chemistry, the final examination, which is KJSEA, they were not able to do a chemistry practical paper. They were given another theory paper. Why? Because of lack of labs. These labs are in senior secondary schools and they are underutilized. So that is the reason why we really need the autonomy of the JSS. Autonomy power. Finally, hardship allowance. The government has announced that it is going to revise the hardship areas. As Narok County, this is what we are saying. Narok County as a whole is a hardship zone. We don't want any of the schools to be removed from that list. And if the government dares Narok County, we will go to court because this thing came through an act of parliament. If it is to be removed, it has to go to the parliament. You parliamentarians, if you dare to touch the hardship, don't come and ask teachers to vote for you next year.
I'm here to talk about confirmation of our junior school interns. Thousands of junior school interns have continued serving despite uncertain employment terms. They have shown competence, commitment, and sacrifice in supporting the competence-based curriculum. It is unfair to keep them in temporary position while Kenya still face teacher shortages. The continued engagement of 44,000 intern teachers on contract term is considered unlawful following the Court of Appeal ruling against internship. Na tunaambia serikali kuwa nimeona advert inatolea 20,000. We are saying the magic number is 44,000. All these teachers should be confirmed as fast as possible without delay. These teachers handle responsibility like permanent employment, staff, and should not face exploitative temporary arrangement. Immediate confirmation and permanent employment of all junior school interns is necessary to ensure fairness, school stability, and legal compliance. Corporate power, interns power. These teachers should be confirmed by the beginning of this term. If not, walimu tutarudi street.
Arenayo abwatikene nekerero kyabarimu bana tukwiranirira ekinagyo kuruswa bisirigathe gashagwa ekendretase ekigambiro kya milimari ase omuchuyo ga Nairobi gwikira boni ganara lya yagendera tukuru ase ensemo eyo gwetira ase abayigereria gwarigathe gashagwa rigathe gashagwa nigo atiganire nengana gose nigatiganire nokukani kwa ekwirani gwa bisibu no mokonyi bwo muraibwense eyunase enseme ntangani okuno kukugania gose ainaro aeresire ekigambiro buna bono takani tikwirani gwa bisibu buno mokonyi bumrai wense korende kiriaganeti nkerina anyarega kwegwa engeria yonsi eriaganiri konyora buno mokonyi bumrai wense engaki are obisi ase egento kende gya kabere nkerina nigo aganiri anyarega kwegwa kerekemo kiria omokonyi bumrai wense aganiri konyora abo ebine bintu bitatu byengencho ase kinikendere temambia bono asa tugutera ari gose atiganire no kugania kwaye gukwira ni gwobisi buno mokonyi bumrai wense egya kabere nkerina aegwe engeria yaye yo buna omokonyi bumrai wense nabo igekya gatatu nabo igo aikirani gubyonsi biria omokonyi bumrai wense aganiri kwegwa engaki ale obisi weterase omwegererio ye Paul Mwite uyo koraibe abayegereri bande asense mwende nigo Paul Mwite aresire na okurusi wa obisi kwari gathigashagwa nigo kwabete gukwayererigwa asembero mono igo ichikondiyo lyabwate twegose katiba tiyabwate tiwe ase umurubiri uri bwensi pigwo korusia omokonyi bumurai bwense abisi asense mwende ase boigo Paul Mwite aerere igoro yengana yokorwara kwari gathigashagwa engaki eria ekina kyara gotegererwa se bunge eria ye senator engaki yo na rwarite abwaste koirwa nyagitari abwasa tebire na keroyo mubuna mwanya bantu ndigaerere buna mwanya bantu onde tayo ukweganeria kurwara korende kurwara negento kegocha mubasokano kine kyo Paul Mwite aereire abana chebi na sikambiro kemilemani buna asa tebire buna mwanya bantu onde tayo ukweganeria kurwara gose buraire bonde kurende oburere nigo bogwocha engakiende yonsi mubasokano gose mosiabana igo aina igati ari agendera tukurwase ikambiro keri kyamilemani ntogendera ukumanyia amange mono buragendera tukurwase ensemeyo engakibona ya mase ye mongo koira paka ase ikambiro keri kyamilemani erio togendera koligerina naraliaya agendera tukurwa ase ensemeyo gekoraga chinsa isano nebere chabona babaso edina nairane nayande amange eri agendera gukumanya naraliaya agendera te gwatika ase eritukeriga lyalero asebono nigonko gotiga iriogendera gotengera naraliaya agendera tekuru asekambiro kirikya milibani ereteriane Ishmael Mogere kuikanande ngakiende.
Look at page 60 of the Hansard of 16th October 2024. So on the attached the affidavit of Jeremiah Nyegenye as Annex JN10. The following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate captures me as asking this question. Do you still stand by that part of your allegation that he has not presented the complaint to the Judicial Service Commission as at that date? The motion mover says, I have since learned that he did present the petition. The motion mover is conceding that he's claiming the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation to the JSC as at 26th September 2024, that allegation is not true. Is it? The motion mover says, we are in agreement, counsel. The motion mover concedes that the ground on which his motion is founded, ground 4, cannot be substantiated. With this Hansard before them, members of the Senate voted to approve this ground. Can it be said that in view of this concession by the motion mover, that ground had been substantiated, that it passed the threshold? The third aspect I want my lords to reflect on when you retire, you can answer this question either way. Some of us enjoy reading these judgments either way. But I want direct answers to these questions. A judge has had a case and delivered a judgment and become functus officio. Can a verbal criticism of the manner in which that judge conducted herself in that case constitute a violation of the decisional independence of the judge? That's what the ground said. It said gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Can a verbal criticism of a judge, because of a decision she has already rendered and become functional official, amount to a threat to the decisional independence of that judge? Which decision? She has already rendered the decision. I submit to you, my lords, that it is actually good democratic practice to subject judicial decisions to heightened scrutiny. It is good practice. It grows judicial accountability. And therefore, what the Senate did by approving this ground was a clawback on an important democratic practice of enhancing judicial accountability. The two grounds that I want to deal simultaneously are grounds 5 and 6, because they suffer the same fate of inadequacy. Grounds 5 and 6. Ground 5, and both of them were approved. So I've already dealt with one that was approved. I'm dealing with two others. Then I'll deal with two others to finish the 5 that were approved. Ground 5 accused the Deputy President of gross violation of Articles 3.1 and 148.5a of the Constitution and fidelity to the oath of office and allegiance. Then ground 6 provided that the Deputy President, that there were serious reasons to believe that the Deputy President had committed a crime under sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Those were the two grounds. So, a ground must be supported by particulars. That's what the Supreme Court has said. Then the particulars must be substantiated. Now, when you look at the motion, ground 5 had no particulars of its own. Ground 6 had no particulars of its own. Instead, what the drafter of this motion, in his drafting wisdom, did was to say the grounds in support of ground 5, the particulars in support of ground 5 are the particulars in grounds 1, 2, 3, and 4. That's what he said. Similarly, in respect of ground 6, the drafter didn't supply particulars. Instead, he said the particulars in support of ground 6 are the grounds set out in the particulars set out in grounds 1, 2, 3, and 4. My lords, as experienced jurists, you know better than I do that particulars are the specific acts or omissions constituting the wrongdoing. The specific acts or omissions constituting the wrongdoing. The National Assembly went to the Senate and said, we are charging the Deputy President in ground 5 and ground 6 because of the acts and omissions we have referred to in grounds 1, 2, 3, and 4. Is that a permissible way of framing a charge of impeachment? I began by setting out that it has been established that the grounds, the charges in impeachment are framed in the same manner as charges in a criminal case. This court, the High Court rather, has held in 3 different cases. The case of BMK versus Republic, 2020 EKLR. the case of LKO versus Republic, 2022, EKLR, and the case of Etiang versus Republic, 2022, EKLR. I'll just refer to one because they make the same principle. Yes, Zongudi said, and I quote, "The problem I find in the charge sheet is one of multiplicity of charges." Then she defines multiplicity. Multiplicity in a charge sheet arises from charging of a single criminal act as multiple separate counts. This may result in violation of the right of an accused person under Article 50, Clause 2, Paragraph O of the Constitution. That multiplicity of charges is a violation or a threat to Article 50, Clause 2, Paragraph O. And it defines multiplicity to mean charging a single act as multiple separate counts. So therefore, when the National Assembly tells us that the acts in ground 1, 2, 3, 4 are the same acts that constitute the ground 5 and ground 6, these two grounds were bad for multiplicity. They were a violation of Article 50 of the Constitution. They cannot found a threshold for impeachment. Both of the two grounds were approved by the Senate as constituting the basis for removal of the Deputy President from office. But there's something very bad about it. The Senate voted to approve grounds 5 and 6 on the particulars set out in 1, 2, 3, and 4, and ground 5 on the particulars set out in grounds 1, 2, 3, and 4, but acquitted the Deputy President of grounds 2 and 3. And remember, they gave no reasons for convicting. And that's how obscene this trial in plenary is, as my learned colleague, Mr. Chel Dudley, will take you through in a short while. Then finally, ground 1. Ground 1 accused the Deputy President of gross violation of Articles 10(2)(a), B, and C, 73(1)(a) and 2B, 75(1) and C, so 75(1)(c) and 129(2) of the Constitution, and Articles 47(1) as read together with Articles 131(2)(c) and D of the Constitution. In summary, my lords, these were the grounds that accused the Deputy President of talking about shares in government and shareholding in government. Let me just paraphrase it like that. That's in summary what this is about. My learned colleague, Mr. Tom Masharia, took the motion mover through cross-examination on this ground. You will find that at pages 88 to 94 of the Hansard of 16th October 2024. So a number of things emerged. I just summarize them. Number 1, the motion mover confirmed that the government of the day in Kenya is formed by a coalition of parties named the Kenya Kwanza Coalition. Motion mover confirmed that as a fact. Number 2, he confirmed that the Kenya Kwanza Coalition was formed of pre-election coalition agreements involving various parties. Number 3, among the parties were UDA, ANC, Ford Kenya, and PAA or PA, as is sometimes called. And my lord, this must come out very succinctly from me. It bears that PA is the party whose party leader was the Speaker of the Senate presiding over these proceedings. When you finally take time to read pages 88 to 94, the motion mover confirmed that each of these coalition agreements made references to sharing of government. And they expressly spoke about sharing government positions and sharing resources. You'll see the coalition agreement between Ford Kenya and ANC talking about certain roads in Western Kenya, nowhere else. You will see the coalition agreement with the PA talking about development of marine resources in coastal Kenya. You will see positions, the leader of Ford Kenya being promised the position of the Speaker of the National Assembly and certain cabinet portfolios and principal secretary portfolios. The leader of the party called PA being promised a position of the Speaker of the Senate. The question, therefore, is that when parties enter coalition agreements and pre-election manifestos, it is the people who determine whether they want to be associated with that kind of manifesto or that kind of pre-election arrangement at an election. For some reason, the people of Kenya chose this agreement with shareholding arrangements in 2022. If the people of Kenya are unhappy, they have another opportunity in 2027 to deal with it. And that is exactly what the High Court set out in the Ensoko decision that I have just referred to. If you look at the High Court Ensoko decision at paragraph 258, the High Court says an impeachment is an important remedy, but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. If the people of Kenya had gone to the 2022 elections on the strength of these pre-election arrangements that talked about shareholding, it follows that they had a chance to revisit that question at the next election cycle. That's what the High Court is telling us. But, my lords, the more interesting one for me is at page 95 of the Hansard of 16th October 2024. You'll find the following very interesting conversation between Counsel Tom Macharia and the motion mover, Ecomas Mwenge Mutuse. I'll briefly take through the conversation, my lord, but you will take note of the pages and revisit it when you retire to do duty of writing judgment. Tom Macharia begins by playing a video to the motion mover and puts the question, who is speaking in that video? The motion mover, Mwenge Mutuse, responds, the President of the Republic of Kenya, Honorable William Ruto. Tom Macharia then poses the question, which words did he use? What did he say to the people of Murang'a? Mwenge Mutuse says he has appointed many of the locals into his government. Tom Macharia prods further, did he say nyinyi watu wa Murang'a ni shareholders wakubwa wa hii serikali? Mwenge Mutusa says, yes, he did. The people of Kenya have no difficulty waiting to assess their president at the next election cycle in 2027 following this conversation. The question we want you to deal with is this. Why is the president's reference to the people of Murang'a as shareholders in his government acceptable political rhetoric? And a similar reference to the people of Nandi and Kericho, because those are the areas mentioned in the motion, by his deputy, an impeachable offense. It's worth noting that when you read the conversations I've told you at pages 88 to 94, you'll find that the person who witnessed the pre-election pacts in Kenya Kwanza was Professor Kithure Kindiki, and despite witnessing agreements with the shareholding model in it, the National Assembly had no difficulty approving now to become the deputy president. It is that uneven-handedness that we want this court to ask itself this question. Did the National Assembly find a wrong, then sought to establish who is the wrongdoer to be punished, then found the deputy president? Or did it find the deputy president, then asked, what wrong can we put on him to punish him? Which is what appears to me to have transpired in this set of circumstances. I have taken you through the 5 grounds that were approved by the Senate to demonstrate to you that they were bad for multiplicity. That's grounds 5 and 6. They fell short of the threshold as set out in Article 150 of the Constitution, as expanded upon through judicial interpretation. And therefore, generally, they could not found a motion for removal of the deputy president from office. While principally, therefore, beseeching this court to allow this petition, allow me now to invite my learned colleague, Mr. Chel Dudley, to take you through the reading of the constitutional prescription on the impeachment procedure and how the interpretation of those provisions by the Speaker of the Senate fell way off the mark. Mr. Dudley, you're welcome. Thank you, my lord.
Thank you. Thank you, my lord, for the opportunity to address you on this important question. When we last left the court, I had thought that we were done with jurisdiction, but the National Assembly spends the first 32 pages of their submissions saying that you either lack jurisdiction, or if you have it, then you're limited to looking at the process. And you should not hear the substantive violations that my 2 colleagues have told you about. They cite, quite helpfully to us, a Filipino case, Francisco versus House of Representatives, where the Filipino Parliament had similarly argued that the Filipino judiciary had no jurisdiction to review impeachment proceedings. The court concluded that that process has procedural safeguards, and therefore it answers to a legal process.
My Lord, that stance, the stance that the proceedings you're dealing with are both political and legal, is found in the report of the Technical Working Group D on the executive. My senior counsel team leader, Paul Mwito, was a delegate number 114. The current speaker was delegate number 209 at the CKRC conference. And you'll hear Professor Githu Muigai, when he rises, tell you that these provisions on impeachment were hotly contested. They were the most contentious provisions. And so, my Lord, detail was paid to these provisions. The law is that Parliament does not waste words. Every word in a legislation must be given a meaning. Now, let me begin with what's common ground. On 9th October 2024, JN4, the affidavit of Jeremiah Nyegenye at paragraph 22, the morning sitting, in the Hansard, the Speaker of the Senate misleads the Senate, saying that we have two options to deal with this motion, alike the procedure for governors and deputy governors. He says we have a motion, is the first, for impeachment of deputy president, but we have two options that we have when it comes to the impeachment of deputy governors and governors. My Lord, that is a heresy. And because of that, just common ground again, the Senate does not form the committee. The special committee under Article 145(3) is not formed. Why? The Speaker misleads the House that they have two options. They can either investigate the charges by committee, Article 145(3)(a), or they can investigate by plenary, like they do for governors. My Lord, I request that my Lords be given our rejoinder submissions, table 1, because I intend to spend a moment or two there. My Lord, the Senate picks the 10-day timeline applicable to the special committee. Remember, they've dropped the committee. They've said, no, we have two options. We are investigating it in plenary. But they retain the 10-day timeline applicable to that special committee. And so, when the Deputy President falls ill, my colleagues have addressed this, the Speaker holds on to the 10-day deadline applicable to the special committee for a plenary hearing. And the members of the Senate vote to deny the Deputy President even the benefit of that 10 days, the balance of it. They say we must conclude our business today. In doing that, the Senate grossly violated the Constitution. My Lord, let me bring your attention to Table 1. In Table 1, we've tabulated the differences between Article 145(3), Senate Standing Order 78 and 80, and Rule 2, Rules of Procedure for removal of the Deputy President by impeachments and governors. My Lord, Article 145(3) does not give two options, it gives one option, and it says that within 7 days after receiving notice of the National Assembly resolution, the Senate Speaker shall convene a meeting of the Senate to hear charges against the President, and the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter. The special committee has a constitutional function. It investigates the charges for seriousness. Then it reports to the Senate. My Lord, there's a may which seems problematic here, but we'll tell you where that may originated. But as it is, it makes grammatical sense. The Senate must convene within 7 days, and if the Senate convenes in 7 days and the motion is approved, there's something worthy of investigation here, the Senate may appoint the committee. It must not appoint the committee always. Why? Because sometimes you'll find that it's flimsy. The charge is that the deputy president, the president, wore a yellow shirt. He should have worn green. Or he wore a blue shirt when he should have worn a red one. Flimsy charges. My Lord, the test on threshold has already been laid to you. So literally, grammatically, Article 145.3a has an and. If you go to 143.5b and you begin with the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter, and you leave the A, what have you done to the and? And is disjunctive. It means you must bring both elements of the law together. Parliament does not waste words. Every word used by Parliament in a law has meaning. And the court must give each word in the law meaning, especially if that law is a constitution. My Lord, staying with Table 1, Standing Order 78, which is a provision applicable to the President, reflects faithfully the wording in Article 145.3, word for word. Then, this is where the original sin happens. Standing Order 80, and that is on page 2 of our Table 1. I really hope that my lords have it so that we take this argument because it's a technical one and it's on the details. But when you come to Standing Order 80, which is the procedure applicable to governors and deputy governors, it allows the Senate to investigate in plenary. Standing Order 81 says, within 7 days after receiving the resolution, the Speaker of the Senate shall convene a meeting of the Senate to hear charges against the governor. And the Senate may, 1, by resolution, appoint a special committee comprising 11 of its members to investigate the matter, or investigate the matter in plenary. The Speaker imports this or in Standing Order 80, brings it to Standing Order 78, replaces the and there. The Senate shall convene and may by resolution appoint a committee. He replaces that and, he deletes it. He uses or. So he tells the senators you have two options. You can go investigate this by special committee, or you can investigate it by plenary, like we do for governors. My Lord, if you look at the constitutional article for impeachment of governors, you will not find the kind of detail that you have in Article 145. Why? My learned friend, my senior Professor Guido will tell you that this Article 145 was intensely debated. It was one of the most contentious provisions in the history of the making of the Constitution. So it comes complete with detail. But the Speaker here replaces the word or in Standing Order 80 and takes it to Standing Order 78 to Article 145.3. He deletes and implants or. What misled the Speaker could be is Rule 2. My Lord, that's the last item, number 4, on page 2 of our Table 1. Rule 2, Rules of Procedure, also makes the same mistake. It replaces the legislative word and in Article 145 with the or, disjunctive. My Lord, Rule 2 says the Senate may in plenary investigate the matter and determine whether the particulars of the allegations against the President have been substantiated. It has now omitted. The special committee is gone. So Rule 2 goes to 145.3 and then descends to B by plenary. It's saying the Senate may investigate by plenary. Where did this error originate in the making of our Constitution? My Lord, I go to that because if suppose we are not making sense and our argument is too full of grammar. The theory of holistic interpretation requires you to look at the text, which we have done, and the history. What was the history? And how did we end up with a provision that, quote unquote, could sound difficult? My lord, the theory of holistic interpretation is mainstreamed as a theory of interpreting our Constitution. Let us then travel back in time to the Bomas Conference. But my lord, before I do that, allow me to draw your attention to a fresh new publication of the Senate. And that is a digest of the law and practice on removal of county governors and deputy county governors from office through impeachment. First edition, brand new, published last year. I apologize, I haven't yet produced it to the court. I intend to do that, but it's also available online, thanks to the Senate. My lord, the Senate worries about this process. It says committee vis-a-vis plenary proceedings. And the Senate, this is about governance. It says that the law does not provide for any specific procedure. Page 104, a case digest. You do not have it yet. I've just apologized that I came across it yesterday because it's a new publication, but I will put it on record. When you turn to it and you look at page 104, you'll find that the Senate says that the law does not provide for any specific procedure. As a result, the county assemblies and the Senate are not bound to follow any route. That is what informs the rules of procedure, where the Senate may investigate. And that is also what informs Standing Order 80, where the Senate may use plenary to investigate. But, my lord, the Senate recognizes what this court has in Sonko High Court. This court said that we are of the considered view that impeachment of a governor is a serious undertaking. The impeachment of a deputy president, of a president, is a more serious undertaking. For this reason, we recommend that it will be desirable in future impeachments to proceed through the committee route as opposed to the plenary. This High Court has recognized the inherent risks in investigating through plenary. Why? We say so because when the special committee is appointed, the Article 145 3A committee, it has 10 days to deliberate on the matter, thus giving many opportunities to the parties to prepare their cases adequately. The committee gives the perception that each member is actually engaging in the process as opposed to the plenary, which can be perceived to be a mob lynching process. That's exactly what happened here. The investigation in plenary was a mob lynching process. The Senate goes on to say that trial by the committee, page 105, a case digest on removal of governors and deputy governors, a publication of the Senate, brand new 2025 bond. Trial by committee gives the Senate, through the 11 members, an opportunity to review the usually voluminous documents from the governor's team. A trial by committee over the 10 days would have given the Senate the time to review.
As a request, we clarify the record while my colleague is addressing that point. In his written submissions, that decision is describing, it is described as a decision of the Supreme Court, but it is actually a decision of the High Court. So that we don't have to later belabor this point now that we're addressing it. Can he confirm? Because the written record says it is a decision of the Supreme Court, but it's actually a decision of the High Court.
I'm grateful that my learned friend, Mr. Mudomi Thiankol, a very good friend of mine, felt compelled to interrupt at this point, indicating its importance. It's an easy one. The decision is High Court Sonko. There's a typo saying it's Supreme Court. It's High Court, but it's what the court has said. Now here, at page 105 where I was, the Senate is speaking to a member of staff of the Senate involved in this process. That's what this report highlights there. And this member of staff, I hope it's my learned friend Ms. Tanji, is saying that trial by committee, the special committee under Article 145, 3A, gives members and would have given the deputy president's team enough time to interact with the senators on the voluminous record. Because of the fewer members, the committee is able to probe and follow up with specific questions, especially where the grounds for impeachment are technical. Perhaps the committee would have caught out that in Robert Alai, a case I was fortunate to argue with my learned friend Mr. Ongoya, the court had already nullified section 132 of the Penal Code on undermining the authority of a public officer. Well, this did not happen in this case. And finally, it records here that the plenary, it also says that there are some benefits to the plenary report as well. My Lord, in short, what you are saying is that the motion to impeach the deputy president was contingent on the special committee's report. It's not just procedural. There's also a substantive right given to him before that committee. Look at Article 145(5) of the Constitution. The deputy president has a right to be heard before that committee. The committee investigating the serious charges leveled against him. That step was omitted. That's a grave violation of the Constitution. My Lord, the final chance that he had to be heard was also denied to him, the adjournment. When something like that happened in a case that my friend, Professor Ojenda, Senior Counsel, argued with his usual merit, Onyango Law versus Kisumu County Assembly, Service Board, 2025 Kenya Court of Appeal 333, the Court of Appeal was persuaded that Onyango Law had been denied a fair hearing. And just like in Oloma Law, the Senate here speedily approved the motion, skipped that special committee altogether, but retained the 10-day timeline. I wonder what the 10-day timeline was doing in a plenary setting where the Constitution does not impose that 10-day timeline, but requires reasonableness. It obviously can't delay until the end of the term, but that 10-day timeline was a stranger in the process. And so the Court of Appeal was persuaded that Onyango Law was unfairly impeached. My Lord, we ask you to take the Onyango Law decision and...
I don't like interrupting things at all. But just Onyango Law was given 1 hour. The Deputy President had 10 days.
My Lord, whereas the special committee would have had the deputy president over 10 days, he was investigated in plenary over 24 hours and impeached in his absence. So I ask you again to take the Onyango Law decision, and where it says Onyango Law, please substitute Rigathi Gachagua and make your decision. My Lord, let me take you to the drafting history of our Article 145. It was not initially there as Article 145. And my Lord, the theory of holistic interpretation requires you to consider our social, our political, our historical context as a people. That history has names like Oginga Odinga, mistreated by the president, unfairly removed from office. It has Kungu Karumba, George Saitoti. At some point, Not appointed at all, reappointed after the elections. I forget which year, I was a young boy then. But in your ruling of 31st October 2024, my lord, you recognize this history and you said that the vice president served entirely at the president's mercy. That was a framework that the 2010 Constitution sought to transform. And under the 2010 Constitution, the office of the Deputy President is fundamentally redefined. Your words? It was safeguarded from arbitrary and capricious actions by the President. Before the Senate, on 16th October 2024, another good friend, Senior Counsel Otiende Amolo, a former member of the Committee of Experts, who was familiar with the drafting history of Article 145, reflected as follows, and I quote, "Before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes." So my example of the color of his coat was not so far-fetched. It is on the answered record. My lord, that's a correct reflection on the intention, on the history, on the motivations, on the framing of Article 145. In the National Land Commission versus Attorney General Supreme Court advisory opinion, the court held that unlike the independence constitution that failed to articulate the history and struggles of the people, the 2010 Constitution integrates that history and the people's view. And so, my lord, when you turn to interpret Article 145 and you encounter the challenge with the may appearing in the second part of it, in 135 3B, and you wonder why does it appear this way, you must remember the history. Speaking of history, at page 182 of the CKRC final report, and that, my lord, is a lawyer's Bible, is a constitutional lawyer's Bible. It is the reference point for ambiguous text. We go back to it to see what was the intention here, what was the struggle, what was the mischief. The people said that, I quote, "there should be adequate mechanisms to avoid the risk of impeachment being used for purely political motives." Page 802 of that CKRC final report records that impeachment was one of the most contentious issues leading to extreme polarization among
Eye Ensoko TV, oboroso bumu